Arizona versus Gant allow you to search a car as incident to arrest after arresting somebody for robbing a pharmacy a month ago. Hey guys, my name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you another roadside chat. All right, this officer, I don't know who this officer is from, it doesn't really matter, but he said, look, we had a suspect commit a pharmacy burglary, burglary, out in our area about a month ago. We were able to identify the suspect using cell phone data and arrested him for the burglaries a month after the crime occurred, and he was in a vehicle. Unknown if this was the vehicle used in the crime. My question is, do we have any authority to search the car under probable cause or Arizona versus Gant? My first thought was that we did not have enough to say it was probable that we would find evidence for the crime due to the amount of time that had passed, and also we were unsure if this vehicle was used in the crime. But I thought we may have enough for a reasonable, there was reason to believe that it was lawful under Arizona versus Gant, right? Anything that you can cite as a reference. All right, so let's just kind of do some groundwork here, and so we can answer the question. The first thing is that, generally speaking, you can recover evidence from a vehicle, one of three ways, right? The first way is with consent. Certainly, we should ask this person for consent. Hopefully, they'll give us consent, right? But if they're not going to give us consent, that's fine. The next thing is probable cause. That's the next most common way, maybe the most common way, but it's the next most common way to recover evidence from a vehicle. The motor vehicle exception has been around since 1925. It started in a case called Carroll, and it's been reaffirmed multiple times by the U.S. Supreme Court. And it says that we can search a vehicle without a warrant as long as we have probable cause for the vehicle is not on curtilage when we found it, the vehicle is readily mobile, right? And when you search it as if you had a warrant. In other words, what would the court allow you to do, right? Would they allow you to search the trunk? Would they allow you to search the engine compartment? And so forth. So if you're looking for an iPad, should you look in the eyeglass holder? Probably not. If you're looking for drugs, can you look in the eyeglass holder? No problem. Then the final one is Arizona versus Gant. Now, Arizona versus Gant was a good case and a bad case for law enforcement. What happened in Gant was that officers in Arizona arrested Gant after he exited his vehicle for no license and had a warrant. They then went up to the vehicle and searched it as incident to arrest. Now, you got to give these cops some credit because in 2009, well, that's when it was decided, but prior to 2009, it was very common for police officers around the nation to routinely search a car as incident to arrest. In other words, all they cared about was that you came from that car and then you got arrested, right? That car was in your immediate possession at some point during the law enforcement contact. This was what lawyers, police officers, and so forth determined was the holding in a case called Belton, right? A case out of New York. But the Supreme Court said, actually, that's not what we meant, right? Well, they kind of blamed us, the people looking at the case, and said, well, you kind of misread it, right? It's not our fault. You just misread it, but yet the Supreme Court allowed it to continue on for, decades. But the point is, they said, you know what? It's not simply enough that the person came from that vehicle when they were arrested, right? If you're going to search it as incident to arrest, for officer safety reasons, you also need to have a reason why and how they would actually access that vehicle at the time of the search, right? At the time of the search, not the time of the arrest. And that's very key. And that's actually changing a lot of things around the country. But regardless. So when you search a vehicle as incident to arrest, the classic search incident to arrest methodology, you have to ask yourself, is the person even near the vehicle? Can they actually access it? Are they restrained or unrestrained, right? At the time that I'm searching. 99.9% of the time, these people will not be near the vehicle, right? The suspect is not going to be near the vehicle while officers are going through it to try to search for this evidence. Therefore, this search that cops have been doing for decades is not authorized in 99.9% of the cases. The suspect will just not be up near the vehicle. Now, some cops will be like, well, I'll just keep them near the vehicle, like, no, or unrestrained. No, we do not play games like that. The Supreme Court actually warned us that that would not be lawful. Either they're near it or they're not. If they're not, we move on to the second Gant exception. This is where it was actually good for us. They said also that if we have a reason to believe that offense-related evidence of that crime is inside the vehicle, then it is lawful to search it for evidence of that crime. Okay, so reason to believe is like reasonable suspicion. That's a pretty low standard, and I think, one of the best cases on this is People versus Crum, Colorado, 2013. So just 4 years after Gant, they said this. Contrary to the district court's reasoning, however, Gant does not preclude a search of a vehicle if it is conceivable, that's a pretty strong word, that the vehicle might contain evidence of the crime of arrest. Nor did the officers need to articulate reasons to believe that there was something illegal in the vehicle, or that Crum was fleeing the vehicle because he knew it contained contraband. Even if it is possible that the vehicle might not contain further evidence, the officers could still have a reasonable articulable suspicion that it might. Nothing more than this is required to permit a search of the vehicle. Okay, as applied here, then if the facts and circumstances applied a reasonable articulable suspicion that the SUV might contain evidence of possession of a controlled substance, a crime from which there was probable cause to arrest, then the search would satisfy the evidence gathering rationale set forth in what case? Gant. Now, this is a pretty strong case, right? The language is great for us. And look, I want to teach us to win at the Supreme Court, not just at a state Supreme Court. But I do agree that the standard is very, very low. But, however, if we go to court and we say, and they're asked, why are you searching this guy's car a month later? We don't know, blah, blah, blah. And now you're like, well, it's possible that there's evidence of the crime in the car, then that's not reasonable suspicion, okay? Reasonable suspicion is not a possibility. It's at least some degree of probability. Now, when I say probability, I mean strictly the word probable, right? Probable is just a level of proof, right? So I don't necessarily mean probable cause. Reasonable suspicion is some level of probability. It's a low level, but it's right? And all the way up to beyond a reasonable doubt is also a level of probability. Going back to our case at hand. I don't like it if we have nothing to tie this car in to the burglaries. However, okay, I think we probably could come up with something here that's legitimate and real and not just far-fetched. For example, it's his car, right? He's the registered owner. Or you have evidence, you have reason to believe that he actually commonly drives this vehicle, right? That is probably that could be maybe enough. The other thing is what was stolen during the burglary, right? If all we have is, he stole some pills, right? Maybe not an incredible amount of pills. I don't know. A month is a long time for an addict, right? I mean, are we really expecting to find more evidence of that pharmacy robbery, burglary a month later? These pills are either popped or they're sold, right? However, if there was an incredible amount of evidence, prescription drugs stolen and other things that are hard to sell, like some durable goods or something crazy like that, then maybe there was more of a reason to believe that something is still left in the car. If he is suspected of also being involved in other burglaries, that this is his lifestyle, he goes around and does pharmaceutical burglaries. I don't know, but you got to have something, right? You can't just go to court and say, well, Your Honor, what? I mean, this is not even a crime. Like if it was a murder, if it was a murder or a sexual assault, that would be way easier to articulate than something that is kind of, temporal, like a burglary at a pharmacy, like that these drugs that these people steal are just often just sold or consumed, right? So that's what I want. I don't have enough facts. I don't know, but it's not, as you know, in this case, it's not very high burden. I'll leave that Colorado case in the description below. You can read it for yourself, but have something more than nothing. Okay? So at the end, I want to know more facts before I would actually sign off on this. But for the most part, it shouldn't be that hard. If you have any questions about this, let me know in the comments below. If you like what I'm doing here, you do me a favor. Like, subscribe, share this with your friends. And until next time, my friends,